I want to ask you the same question, Mr. Alhassan, about what lessons the incoming CJ needs to learn. Of course, admitting the fact that there is a need to look at our constitution in the current state as it is.
Thank you. Do I have the benefit of also responding to some of the issues raised by Madam Gloria? First and foremost, we must recognize that our contribution to the discourse is to educate the public, to set the facts right. Now, when you say there's a need to have a union or coalition government, I don't know at what point that idea was conceived, but in 2017-2020, Madam Gloria was in this country. Nana Addo was the president, and I have no doubt that at the time she had this idea. She never proposed this to the government.
How do you know she didn't?
I know her. I know she had ideas at the time, and I'm convinced that she had this as part of her ideas at the time.
Yes, but you're saying that she didn't. How do you know that she didn't propose it to the president?
The same medium could have been used. You don't need to use private sources. This is the medium she's using today. She could have used the same medium at the time. Radio stations and all that. Make your views public. So that's the first thing to deal with. So it's not as if it's alien to our democracy. It has always been the case. And you cannot all of a sudden start arguing that there's the need to have a union government. Everybody wants that. But until you have demonstrated that the party that you also align with, you are giving them those suggestions and they rejected. That's when you can be arguing.
Well, hopefully she has the opportunity to respond to that because she cannot conclude that she didn't do that.
Very well. That's why I'm saying that I need to respond to that. Now, the other thing has to do with the issue of whether some committee members met some other lawyers who were against the CA and all that. I think these matters came up and we dealt with them extensively. The person at the center of the issue came out publicly and denied this. And the matter was dead, long concluded and dead. So I don't know where this is coming from. You see, we must move away from emotional arguments to factual matters. The other thing relating to the removal being flawed, where she says who has been removed or who has removed her, as if you are not recognizing the removal process. I mean, that in itself might even amount to an offense.
No, but she's made it clear that she thinks that the whole process was flawed.
No, and I'm saying that her initial remark was that who has removed her?
But that's her opinion.
No, but you cannot say that. The person has been removed in accordance with law.
She's entitled to her opinion just like you are.
I have no problem with that, but I'm saying that I'm speaking to law. The thing is that the person has been removed in accordance with law. And that is the law now. You cannot be saying who has removed her or she has not been removed.
So now the question I asked earlier about whether or not there's any need for lessons to be learned from, by the incoming CJ.
Yeah, the lessons have been learned largely by the incoming or whoever we appointed. In fact, the current crop of Supreme Court justices have learned huge lessons from the conduct of the removed Chief Justice. It means that, you see, when the Constitution speaks about certain qualities of a judge in terms of proving character, high moral character, and proving integrity, they are not just beautiful words being used in the Constitution. They have meanings, and those meanings ought to be interpreted properly. Moral character, you must demonstrate a certain degree of morality. And you know what morality is? Your ability to distinguish between what is right from wrong. Those are the things you should be very minded about. Now, you are also talking about proving integrity. You must exhibit a certain level of honesty, sincerity, and candor in your conduct. Those are the indicators. And so they are not just captured in the Constitution just to make the Constitution sound so lovely or beautiful. But we must leave those words. If you don't leave those words, the natural will catch up with you in the nature of such petitions. Remember, for somebody to argue that the removal is flawed, you should be pointing to the specific provision that has been breached. Because the committee that was constituted on the basis of Article 146. And Article 146 specifically which deals with the removal of the CJ. When you come to Clause 6, once the committee is constituted, it is expected to exercise some level of fairness, some level of due diligence, some level of accountability, even in dealing with the person at the center of the whole issue. Wasn't that the case? When the article says 146.5 says it should be in camera, You cannot be going there with everybody. In camera means in camera. We are lawyers. We should know better. So I was surprised the CJ brought the matter up, complaining that a family member hadn't been allowed in. In camera means in camera.
So the point you're making with the question I asked earlier is that based on what I read earlier, Article 128, Clause 4, that is what the incoming CJ should be expected of, and the kind of lessons that be learned.